Welcome to the Common Law Rights Society. We appreciate you stopping by. Please like and subscribe before we get started. Please enjoy the reading of WEISS'S Concise Trustee Handbook, a guide to the administration of an express trust under common law, functioning under the general law merchant by Carlton Albert Weiss. This is not legal advice. Let us begin. WEISS'S Concise Trustee Handbook, a guide to the administration of an express trust under common law, functioning under the general law merchant, by Carlton Albert Weiss, 2nd edition, published in 2008. Chapter 1, Introduction. Introduction begins. This handbook is about the administration of express trusts created under the original American common law, operating within the unique system of commerce in the American states, also known as the general law merchant, as it stands in 21st century America. The content in this handbook has been condensed from various sources that the reader is encouraged to explore for additional knowledge and deeper understanding. This handbook has been formatted as a concise guide, structured to provide direction on the most critical aspects of express trust administration. The author's objective is to provide a simple guide with clearly outlined methods and sample forms for managing the affairs of express trusts, while also highlighting the growth opportunities, prosperity options, and profound protections that express trusts can offer when created and administered properly. This book is written in an unconventional manner, aiming to meet this goal. If, after consulting additional sources, the reader finds this work lacking in its objectives, let any fault rest with the author, and not with the sources or with the express trust structure itself. As honest and learned-to lawyers will admit, the express trust, particularly when carefully structured, is a form of organization that offers superior security for individuals seeking to exercise their natural rights. Footnote 1 reads, "The general law merchant operates under the principles of common law. This system of commercial law within the American states excludes any regulation over express trusts except regarding income from corporate stock and physical franchises under Article 1, Section 8, Clauses 1 and 3 of the Constitution. Refer to William A. Fletcher, the General Common Law in Section 34 of the Judiciary Act of 1789. The example of marine insurance, Harvard Law Review 97, page 1513, 1984. Footnote 2 reads, Chief Justice Warren E. Burger of the United States Supreme Court believed that 75 to 90% of trial lawyers were either incompetent or dishonest. See Reports of the American Bar Association, Volume 102, pages 205 through 206, 1978. Footnote 3 reads, Historically, lawyer was defined as someone learned in the law. Chapter 2, Trust Basics. Section on Trust Basics begins. First, it is essential to understand that any trust, regardless of its specific designation, at its core is a property interest held by one person, known as the trustee, at the request of another person, known as the settlor, for the benefit of a third person, known as the beneficiary. For footnote 4 reads, Black's Law Dictionary, 7th edition, page 1513, defines a trust as the right, enforceable solely in equity, to the beneficial enjoyment of property to which another holds legal title. The term also encompasses fiduciary obligations, though details are beyond the scope of this handbook due to space limitations. Trusts are classified based on how they are created. They may be established either through a party's direct action or by operation of law. In cases where a party creates a trust directly, there are two primary types, express and implied. An express trust is created with clear, deliberate language, either spoken or written, while an implied trust is inferred from the actions of the involved parties. Though this is a general definition, it is included here for simplicity. Our focus will be on a specific kind of express trust, one that is written and provides protections under the common law. Although this general definition is essentially accurate, it doesn't fully capture the concept of an express trust as it exists in its complete form within common law protections. Chapter 3, Creating a Trust. Section on Creating a Trust begins. Express trusts under the common law can be best understood by referring to early case law, which has been concisely summarized by Alfred D. Chandler Esquire in a report submitted to the Tax Commissioners of Massachusetts. Chandler's definition describes express trusts as placing legal ownership entirely with one or more trustees, while others hold beneficial interest but are neither partners nor agents. This common law right allows any person or group of people who are legally competent to create an express trust without needing privileges or franchises from any external authority. Trustees of express trusts may issue certificates of beneficial interest divided into shares and engage in financial activities as naturally as an individual would open a bank account. Footnote 5 reads, "This definition by Alfred D. Chandler can be found in the report submitted during a Massachusetts legislative investigation into unincorporated associations and their economic impact in 1911. See Alfred D. Chandler, Express Trusts Under the Common Law, A Superior and Distinct Mode of Administration, 1912. Footnote 6 reads, "According to Black's Law Dictionary, first edition, a person sui juris refers to one who has full legal rights and is not under any legal disability or guardianship." Declaration of the Express Trust. Section on Declaration of the Express Trust begins. The Declaration of Trust, also referred to as the trust indenture, constitutes the trust's foundational document. No technical language is required to create a valid declaration as long as the wording clearly expresses the settlor's intent to establish the trust. An express trust typically begins with a declaration of trust, a preference in common law that seeks to avoid legal fictions. For clarity, the declaration should detail the objects of the trust, the property within it, and the intended administration, all in clear, precise language. Footnote 7 reads, George P. Costigan, Jr., Classification of Trusts, Harvard Law Review, Volume 27, pages 437 through 439, published in 1914. Footnote 8 reads, Black's Law Dictionary, page 695, first edition, 1891.
So daily discipline and faith that is consistent, tilling of the soil for the fruit to be abundant, seeking out the wisdom, always be a student, watering the root and bringing forth the remnant. Now who you want to be, which choices will you make? The path of destiny are the choices that we take. And you can start again, and now you're in the wake. Keep intact your vessel and clear the muddy lake. The wise will recognize, realize, prioritize. Get your mind in order, you have to supervise. Vigilant with love, we have to synthesize. Now wise as a serpent, jaloving is the prize. So daily discipline and faith that is consistent, tilling of the soil for the fruit to be abundant.